Good morning, everybody. We will be starting in a minute or two. I see there's still a few people joining, so we will be starting in a minute or two. Good morning, everybody. Thanks, Ilse. Take it away.
Good morning, everyone. And I am, as we speak, still admitting people to our webinar this morning. A hearty welcome from my side. I'm Ilse Spredo. I am part of nFold, and I'm going to facilitate or host our webinar this morning, which is all about protection of personal information, the act commonly referred to as POPIA Act or the POPIA. When I heard the word papaya the first time, I thought they're talking about this fruit that you get on this high-growing trees in the low veld, but yeah, it was something completely different. So, Nicolene, Izane, we're really looking forward to this morning. And just before we start, before I hand over to our expert panelist, I just want to do a quick introduction. And firstly, Nicolene, welcome to your first webinar with nFold. We believe it will be the first of many more to come. It is my honor to introduce you to our attendants or our participants or our guests. And Nicolene has been in the law forever. She is the founder and the managing director of SchoemanLaw Incorporated, which she established in 2007 at the young age of 24. Nicolene's areas of expertise include, amongst others, commercial law. She's a contract drafter. She specialized in PPP EE advice and planning, and very important as well, business continuity planning and corporate governance, to mention a few. Something very interesting about Nicolene is that for 7 years, she presented the law report with Karen Kay on SAFM. And today, or currently, she regularly shares her knowledge on Radio 786 and other radio stations such as Radio Sonder Grense. Nicolene has won several prestigious awards for her academic achievements, and most recently, in 2022, she was the first runner-up of the Warsaw Women in Law Awards in the category Best in Corporate Law. Nicolene, we are honored to have you with us today, and we're looking forward to what you and Izane is going to share with us. So over to Izane, our Chief Master of Inspiration at nFold. Izane is a compassionate leader. She has an amazing ability to develop people. She inspires success through thought leadership, training, and strategy development. Some key highlights of Izane's career is business development experience at global giants. We're talking huge corporates. She was the head of the group bid office for a large listed ICT company before. She published various articles in the past and still currently do on LinkedIn, TFM magazine, Lionesses of Africa. She's an APMP professional certified, which there's only 10 of in South Africa. She presented and still present the AMP, Association for Proposal Management Professional Chapter Committee, and chaired it. And one of the highlights, recent highlights in Izane's career is she presented at the Bid and Proposal Conference in Europe. And it was all about making bid, no bid decisions. And it was recognized as one of the highlights of the conference. So that is your two expert facilitators for this morning. Izane, I'm going to hand over to you and Nicolene. I will monitor the chats, the questions. If there's anything that I need to highlight, then I will alert you of it. And yeah, over to you two. I will switch my camera off for now. And yeah.
Thanks, Ilse. Thank you so much. Thank you. Thanks, everyone, for joining. I'm going to get right to it, Nicolene, in the hot water. So it's about a year and a half ago, 18 months ago, where everybody scrambled to get ready for POPIA. But please remind us, what is POPIA?
Right. Thank you so much for having me and for the warm introductions, first and foremost. So POPIA is the Protection of Personal Information Act. That's what the acronym is short for. And essentially, it's our equivalent in South Africa of international regulations such as the GDPR, the General Data Protection that we know in Europe, which is the thought leader from a regulatory point of view, and to a large extent, which we are aiming to aspire to and mirror with POPIA. So in a nutshell, it's our body of legislation that deals with the protection of sensitive information.
What sort of sensitive information? I thought it had to do with personal information.
Right. So personal information, and I'm not going to bore our participants today with a very long-winded definition in the Act, but if you navigate your way to the POPIA Act in Section 1, there's a definition of personal information. And I often, when I do workshops on the point, say to people, it's better to ask what personal information is not than to ask what it is, because it's such a broad and long definition, almost spanning, if you put it on a slide, onto one full slide of text when we reduce the size. So essentially, in a summation, personal information is a uniquely identifiable part of information, unique to you as a warm body or a private person. In relation to a juristic person, which is one of the key differentiators from our international equivalents, it applies to us as humans, as the warm bodies, as well as to our businesses, with one exception. The minute we die, it does not apply to someone who is deceased. So you have to be alive, or your business needs to be registered as a business within South Africa. And it can extend to anything such as your telephone number, your email address, your age, your gender, your religious beliefs, your cultural beliefs, and the list really goes on and even extends to your medical information.
I can understand that. But why do we need it? Why do we need our personal information, especially the obvious personal information? I'm a white female and I'm alive, yes. And my name is Izane, but why do I need that protected? Why do we need it?
I think if we look at how our world has developed, now, of course, we are all giving our ages away when we speak like this. Most of us in the room, I hope to say, were born in a place or in a time where the flow of information was restricted to controllable media. Now we live in a world where everything is online. Today, we are sitting in a virtual room and we're presenting a workshop, which just a few years ago would have been completely out of our focus that it would be possible. So we have social media, we have the internet, we have so many sources where information can flow from that it needs to be protected. We need to understand what these platforms and role players are doing with our information. We've seen crimes like identity theft and all sorts of things really rearing its ugly head. I cannot put it any better than the judge of the Constitutional Court in Bernstein versus Bester that said the scope of privacy has been closely related to the concept of identity. And it has been stated that rights, like the right of privacy, are not based on a notion of the unencumbered self, but on the notion of what is necessary to have one's own autonomous identity. And that's why I think it's important. Each of us has an inherent right to safeguard that which makes us us. And that's a very broad concept as we see it from the definition.
Now, I don't know everybody in the room, but I'm going to make an assumption that we are not all information officers. Perhaps no one is an information officer. We're in business development. We're in bids and sales and tenders. So what does it have to do with us?
Well, the problem is, and if we look at all the international equivalents from which we've drawn such inspiration and what we are still aspiring to develop into, insofar as our regulations just 18 months ago was introduced, so we are still relatively young at this, right? So all of us, whether we are employees, whether we are suppliers, all of us are bound to acting within a certain way when we deal with other people's personal information. And that could be a client, that could be a potential person who seeks a job with you, that could be a supplier, and the list really goes on. And we really need to start seeing ourselves, whether we're in sales or whether we're in management information officers, that we are the custodians of other people's data. And to a large extent, because it's not our information, it's not our property, we need to safeguard it as we would have had a friend ask you, hey, please hold on to my wallet whilst I go and fetch something. The same kind of care that we would take in that situation, each of us is bound to take in this situation.
Okay, all right. But still, we're talking about proposals and POPIA and proposals. Because when you look at the type of work that we do, whether it's private sector or public sector tendering, well, let's talk public sector tendering. We need to complete SBD forms, your standard bidding documents, and it's the bane of our existence. We all, I don't say we all hate it. Hate is such a strong word, but it's not the favorite part of our jobs. Okay. And of course, when we complete these SBDs, there's a lot of information that goes in there about our companies, but it's also a director's personal information. So what must we consider or know or do or check or not do when we complete SBD forms?
The SBD forms are a requirement, as we all know, particularly in public sector procurement. So from a legislative point of view, we don't have much of a choice other than having to complete it.
Yeah.
Now, whether we have government's commitment and communication around what happens after we submit those documents remains an open-ended question for us in the legal space. We haven't seen any departments publish and say, if you're not successful, we return your documents or we destroy it, or this is how we are dealing with the information from the public sector point of view. What do we have to remember? If I'm the responsible person on behalf of the institution who's entering a bid, and I complete those documents, I'm using my own personal information, or in my capacity as representative of the organization. And that is completely allowable. However, if someone is doing it on our behalf, we need to be cautious as we assist clients or friends, as the case may be, in completing those documents. Because as much as we are using some information that is available on CIPC and public domain, we are also using information which is not in the public domain. For example, our share registries, how many shares are owned by which party. That is not public document under CIPC. So the minute we are starting to incorporate non-public information is when we need to be cautious, and we ourselves need to have a policy in place as to what we'll do with the information, storing it, keeping it safe, etc., once we've done our job as we've been contracted or mandated to do.
Okay. Now, I hear two questions, or these two things that pops into my head. If I'm an employee of a company, I see there's some of my former colleagues here from EOH. So let's say that I'm a bid manager in EOH, and I'm completing the SBD forms. Now, you've just said that there's some public information or publicly available information, and then there's some information that's not publicly available. So I'm, as a bid manager, contracted and employed by EOH, completing a SBD form for EOH. What is my potential risk as an individual employed by the company completing these SBD forms? What must I be aware of?
Well, first and foremost, each of our workplaces in that situation should have incorporated POPIA and all the compliance in relation to that in our HR policies, so that we as employees are aware of what is expected from us. So if the company policy is that we submit bids, and if we are unsuccessful, we need to contact the organization that has received it to retrieve those documents and request from them that they've destroyed whatever copies they have on their records. We need to know what is directed in our policies so that we can follow through on that. We also need to appreciate that when we are acting in our capacity as an employee in that scenario, we need to act in the best interests of our employer at all times. Meaning, if we have policies around, for example, clean desk, clean screen policies, and we are working remotely, completing these forms, we need to be cautious to ensure that there's no breach of the information. As innocent as in a coffee shop, someone walking past and seeing what is displayed on your screen. Or, for example, downloading something that is maybe against public policy and it brings a virus onto your machine, and that way the breach happens. So we need to know how to keep our machines safe and how to keep the information safe in our capacity as employees. And for our employers, we need to talk about this. We need to document it in a policy, or we need to talk about this. We need to workshop this, and we need to be practical, not theoretical on, let's talk about the 8 pillars of POPIA. We need to be as clear as where are the potentials for breach of obtaining a virus onto your machine. Don't download this. Don't go onto an open Wi-Fi network, etc. We need to be practically aware of what the risks are from an electronic point of view, and as well a physical point of view, just to make sure that we take care of what is been entrusted to us.
I'm glad that you talk about practical, because it is, for us, it is a question of what is practical, and give us examples. We very much, when I say we, as bid manager people, we love examples. So still on the same topic. So we talk about SBDs, but now how do we deal with when we have to complete or submit CVs, bios, or an organogram? Very much in the engineering space, our clients want to know it is Joe Bloggs, a registered certified engineer with very specific description of work experience. So they want to know who's the individual. They want that detail. How do we deal with that?
That would be a classic example of personal information that is not in the public domain. Now, fair enough, many of us load our CVs onto platforms like LinkedIn, or we have bios on there, but usually a very abstract version of that. We don't have things like our references by name, their phone numbers, and so on, typically in an open sourced environment like as a platform like LinkedIn, for example. So the minute we are talking about a full CV containing other people's personal information, as by example, references, that is immediately something that we need to ensure we have permission of that particular person to include their CV into our proposal. And remember, that's an informed consent. So we need to ensure that the person supplying the CV and the supporting documents knows and understands exactly what we are doing with it, where it is going, and what we are going to do if we are not successful to retrieve that and to safeguard that, or if we're not going to retrieve and safeguard it. Either way, we need to communicate that. And we cannot say that we have consent from someone if they don't understand what exactly we are going to extract, how we are going to use it, where it's going, and what our thinking is around if we're not successful, or even if we are successful, are we going to retrieve the information, or is everyone okay with it being at a particular government office and staying there? And that the responsibility is then something that we need to talk about from that point of view.
So is it the responsibility of the bid manager to, excuse me, to obtain explicit consent of all the individuals that we are now including in a bid that might be performing the services and if we are successful? So is it the bid manager that must go and contact each of these individuals, or is it an HR function that if I'm employed as a IT technician, I may be placed at different clients, and therefore, just by being employed, I give consent? How does that work? Who's responsible to do it? And the second part of my question is, must I do it every time? If I use Joe Blogs on tender A, and a week later I use Joe Blogs on tender B, and then on tender C, must I ask his permission every time?
So that will depend on the structure of the organization. So if you are able to work it into your HR framework, because the nature of your business, for example, I know I'm going to use this word and everyone's going to cringe. If we're on the business of labor broking, these days you use that word and people think it's a curse.
Yeah.
If that is your business, it may follow in your contracts with your workers or your contract workers, as you've termed them, that it's an inherent requirement of the placement that they allow for ABC. But in a normal circumstance where we have a bid officer or someone responsible for preparing proposals, that may be on a case-by-case basis, and it could be that any provision in relation to permission you've obtained through your HR process may be insufficient. Let's take a typical corporate situation. You employ someone as an IT professional. Let's stick with that example. And predominantly, they are placed to service the IT needs of the organization. But on occasion, we may also, as an organization, enter bids, and then part of your work may transform into delivering services to an external organization or a client or a customer. And if your consent that you obtained during the recruitment process doesn't cover that external engagement, to answer your question, you will have to get permission every time you engage. If it's a regular occurrence, my recommendation from a practical point of view is update your POPIA policy as an organization and say, these people in these positions, this is what may be required of you, and you give consent this is what we'll do, and we have an informed consent document that is then signed as part of the employment contract or as part of receiving the new policy.
Okay, all right. Well, that makes sense. It's clearly it's not just the bid manager's responsibility to safeguard information. But there's other places in the organization where those policies or those principles must be written into. I want to go back to something that you've said a few times that has to do with retrieve or destroy. Now, if government tenders, public sector tenders, it often happens that you submit your response and nothing happens for 6 months or a year or ever. If I heard you correctly, there's no rule yet for how long government must keep information or how they will destroy it. Now, what is our right and our responsibility as bid managers, again, to follow up on something like that? Can you request that it be destroyed, or maybe the people whom you had in your response when you submitted it have now left your company? So I would assume that therefore there's no more permission. So how do we deal with destroying or retrieving?
Particularly in the public sector, this is a big question for us in the legal space, particularly because we've also seen some of our state institutions being victim to data breaches. Just a few weeks ago, our own Department of Justice suffered a very serious data breach, which of course is very concerning, I think, for us as citizens. So it goes to the point that I think the more we develop our thinking around the topic of private and personal information and our rights as data subjects. In other words, the data is no longer this invisible, mysterious concept. It's actually something tangible, which should be dealt with in a responsible manner. I think the more we get accustomed to it and we see how the law develops in our country and abroad, the more you may find that you'll get requests from those individuals who've submitted as part of your bidding process that they want the information back, or at the very least know where it is, has it been exposed, and so on. So as organizations, what we can do in the meantime, because we can't control that environment by any stretch of the imagination, is to say our position is we submit a bid. When we know that it's been awarded and we were not successful, our policy is to send a request for retrieval and to request confirmation of destruction on the recipient end. Bearing in mind, though, that from an auditing reporting point of view, there's also statutory obligation on government to retain bid documents for a certain period of time, even if we were not successful. So it will always be a careful balancing act. And it is left up to us to watch the media and to see when someone takes this very question to one of our courts, for us to have finality around what is expected of us. But remember, although there are many role players in our organizations, ultimately our information officer is the one whose head will be on the chopping block if any of us potentially not follow the protocol. And that may then have a knock-on effect to any of us who have not followed the protocol to face internal disciplinary action, again, based on the HR policies that may be in place, or your contract of employment, or your contract as a whole. So it's important that we take our responsibility seriously, although we won't necessarily be the person being called by the information regulator. We're not the information officer, but that does not indemnify us from still getting into hot water.
Okay. I often think of the silly things that people get sued over, especially in America. I don't think it's that bad here yet. But So we understand it's serious. We understand why it's serious because of identity theft and industrial espionage and that. But are there cases of where it's just been taken to the extreme? Like, come on. Again, everybody here can see that I'm a white female and my name is Izane. Now, what if I go and I see someone called Bronwyn Phillips? I want to sue Bronwyn Phillips because she used my name and she said I'm a female. So my question is, where has this really been taken to the ridiculous?
I think we are lucky in South Africa that we don't, as the legal profession, we often call it litigation-driven. We're not a litigation-driven society. And personally, from a philosophical point of view, I think we should be grateful that we are not a litigation-driven society, because I think it's testimony of the health of society when we see what type of matter ends up in our courts and how often it happens. And it's really no way to live in order to be scared all the time that this may happen to you. So for now, I think it's a good thing, although some of the lawyers may disagree with me from a monetary point of view. We had a recent case as recent as January this year by a Mr. Smuts and Mr. Botha. So Mr. Smuts and a couple of others sued a Mr. Botha. And Mr. Botha owns a farm, and he hosted a cycling tour on his farm. This was all over social media, and some of the cyclists had witnessed what they perceived as animal cruelty happening on said farm, and they proceeded to post on social media about that. Mr. Botha then went to court, wishing to interdict and to claim some damages as a result of what he perceived to be a breach of his personal information. And our courts really weighed up what is personal information, and this is really the first case that gives us a sense of parameters. And they said, listen, the cycling tournament was on social media, and Mr. Botha is not saying it happened outside of his consent. So we can assume he consented to the cycle tournament being on social media. That attributed the farm to belonging to Mr. Botha, as well as the location, etc. And it went further to say anyone can go into the deeds office and say, hey, I want to see what restrictions are attached to this property. I want Mr. Botha's title deed. So that's public document. So the court had a long judgment that it issued and basically said, Mr. Botha, you consented to this. The fact that some of the information which you're seeking to protect now by consent ended up in the public domain has really taken your recourse away. And then it becomes an issue of legitimacy. Is it really animal cruelty, yes or no? And if it wasn't, is that defamatory, which is a separate topic. So the point is really, the minute we consent to anything about us going on Facebook, LinkedIn, any social media platform, we've to a certain extent foregone our remedy under POPIA because it's out there anyway. And we've consented to it being out there. So, of course, it would be different if you go into a coffee shop, you intend to be alone, you're sitting in the corner, and someone comes and takes a photograph of you and posts it with your name or saying something pretty awful. That would be something that will be in between a data breach and probably some form of criminality if we look at the Cybercrimes Act. So whenever we use an electronic tool or device for criminal intent, in simple terms, we are treading on very, very, very dangerous ground, and it's actually criminal behavior under the Cybercrimes Act.
I guess as soon as there are more cases, more case law, some of these questions will then become clearer. Again, particularly in the proposal world. I see that we've got two questions.
Okay.
Thanks, Ilse. Yes, very, very good questions. So Taryn's asking, what is the rule on reference letters? I do know that we are to get permission, but do we have to get permission every time or once off? Many tenders also request a comprehensive list of current clients. Is this a POPIA decision or business? So let's deal with the reference letter question first, and then the comprehensive list of current clients.
The reference letter, I think, if you're lucky enough to obtain one, whether it be appended to your CV or whether it be appended to a testimonial for your business, or as one, whether it is on your website, excuse me, on some social platform or a physical letter, it's important that you, when you obtain it, make the author of the letter aware that you're going to attach it to your CV and you're going to use it, or you're going to use it for bidding purposes, and until you are told otherwise, you will continue to use it. So to place the obligation to revoke the consent on the author of the reference letter side. Communicate clearly, do it in writing. I know getting a reference letter is usually something we do very quickly, and we are usually very stressed when we do it. So when you thank that person, make sure that you communicate in writing what you intend to do with it, and give them the option, should they want you to refrain from using it in future, they can just notify you, and keep that email or that correspondence in a safe place.
Okay. So the second part of the question is we often ask to just list clients. So customer name, contract duration, contract value. Does that count as a reference? So is that a POPIA decision or a business decision?
Personally, I think it's a bit of both. So for us as lawyers, we would need to ask for permission because we are bound by inherent common law attorney-client privilege. The same goes for a medical practitioner, right? They are bound by patient-doctor confidentiality in the same way. So no one has to sign anything in order for it to be confidential. It's an inherent confidence. So I would strongly urge you, if you are in a professional environment where there's a common law obligation for you to ask for permission, please be aware of it. So it's a business decision in that regard. If you're not in an industry with any of these rules applicable to you, then it would be good for you to nonetheless ask for permission to say to your client, we are bidding or we are doing a proposal. Would you mind if I insert you as a reference? And to do the same with your trade references, by the way. To ask them, may we insert your details? We propose we'll insert so-and-so as the contact person, and we will disclose the approximation of our commercials. Is that okay with you? To rather ask for that in writing, get the permission. And I know we are often rushed when we do this, so we are tempted to quickly add it anyway. Rather ask, if you need 3 references or 3 clients, ask for 6 or 10, knowing that there may be a delay in getting the permission. And whilst you're at it, maybe ask for permission until communicated or revoked from their side, as with the references, so you don't have to do it again and again.
I can just see this becoming a challenge where, I understand a potential client wanting references, but I also understand current clients maybe not being willing to act as a reference. So I can see this becoming a big challenge for us as bid managers. Another question, Kyle is asking, what would be the procedure if we do not receive a response from the party we are trying to get permission from?
The simple answer is we can't use it. And if you do use it, you could be opening yourself up to a potential claim. But bearing in mind, remember always our rule of thumb is this public information? So for example, if you've been awarded a bid, many bids are actually published, or the successful party is often published in a public source. For sake of transparency in terms of our constitution. It doesn't always happen, but in some cases it does, in which case it's already public knowledge that you've engaged with this client, and it would serve you well to include that. What I've also seen a number of other clients do, and I thought this was a very interesting way of dealing with this. As they forge new client relationships, and as the relationship starts working for everyone and everyone's comfortable, they actually ask if they can include the engagement as part of their portfolio to disclose for purposes of marketing material on their website and even in future bids. And that way we deal with it before we have an opportunity, and we lessen the likelihood of potentially a bottleneck when we are when we are very tempted to proceed anyway.
That stress of deadlines looming. Okay.
Izane,
Yes.
I there was a very good question from Joanne, talking or asking specifically around consent earlier on. Can your policy?
Sorry, I missed that one. Yes.
No,
Okay.
that's fine. Will you?
I'll deal with that one quickly, and then I'll go to Yaku's question. So, here's a question. Can our policy be to not retrieve our data from the public sector, provided that employees and external contractors are aware of this policy and give informed consent?
In principle, at this point in time, yes. You can also, as a compromise, what I've seen many organizations do is to communicate that it's out of our control to retrieve from public offices, although we do follow reasonable steps to try and do so. If, however, it becomes problematic, we as an organization will supply you the relevant information you may need to go and request it directly from organ concerned. So then you give cooperation so that if that person feels strongly about it, that they can go and they can seek the recourse directly with said department on own accord. And I thought that was quite forward thinking, given this difficult situation we find ourselves in when it comes to public sector data management.
The not. All right. Yaku's saying, security of information. I believe securing information has always been a standard practice in a professional work environment. Example, password protection, not letting sensitive information lie around, etc. What does POPIA add to security of information other than just putting it on paper? So other than just making it official?
I agree. From a professional working environment, it has always been something that is best practice. We've seen the ISO standard in relation to data security being out for a very long time. In fact, it's been out for in excess of 10 years. So very much a predecessor to any regulatory framework. So I agree, it has always needed to be part and parcel of a professional outfit. The problem is very few of us documented it and very few of us trained our people in relation to it. Meaning that even though management may have had a very good idea of what should happen, it never trickled down, statistically speaking, to right down at the bottom of the hierarchy within the organization. Meaning that we still would have seen an innocent email being auto-completed, going to the wrong person, and we never dealt with it. If you've had that situation in your organization and no one's complained, you are terribly, terribly lucky. So yes, we have to document it, but also we can no longer, now that POPIA is with us, say, listen, it's not my fault. My IT person should have dealt with this, or they should have dealt with that. Or I entrusted Microsoft or whatever platform you are using with my data, they're reputable. I had no reason to think that there would be a breach. So POPIA effectively binds the entire supply chain when it comes to the flow of information. So none of us, however our role may be in the supply chain, can really just put our hands up in the air and say, hey, we've documented this. It's always been in place. It's not me. We are compelled to know exactly where the information is flowing and what are the potential pitfalls, and to contract with all the role players we engage with, we allow access to ensure that they are compliant and that they will follow reasonable steps. So It's not just about documentation, it's about accountability, and it's about the practicality flowing down right to your tea lady in your office.
And it's about the reasonable steps. And I think that
Yes.
that is sort of a, thank goodness, because it needs to be reasonable. You cannot control all the information everywhere to the last letter. Okay. Second part of Yaki's question, tender submissions or engaging in new business. If we as a company provide all the correct POPIA documents and agreements required, we know now what it will be used for, how it will be stored, destroyed, etc. How can POPIA prevent any malicious intent from the party I am sharing the information with? It really feels like 80% of POPIA is putting standard practice to paper. There's a second part. So I think it's about, the question here is, how can it prevent malicious intent? Now, before POPIA, you never submitted sensitive information to any party with the immediate expectation that the other party may cause you harm. In fact, a normal service contract provides remedies for breach as well as confidentiality and NDA. So I think the question here is, what has POPIA really brought to breach NDA, confidentiality, and other standard practices that were in place before?
Well, I think it gives us a mechanism outside of our court environment, but not to the exclusion of the normal remedies we would have had through our courts, in order to report someone who's behaved maliciously. If you've agreed around certain confines on the use of the information for a specific purpose or specific period of time, they cannot by law act outside of that framework. And if they do, POPI aims to keep them accountable, including the information regulator, who is able to impose fine and imprisonment. It's serious. So we have this structure which we don't need an attorney to approach. So it's a quicker mechanism. There's an accountability mechanism, and we can do our civil duty to ensure it doesn't happen to someone else. And of course, if we can quantify the damages we've suffered or our reputations have suffered, it means we can also go through the normal legal remedies. The problem that we've always had, though, and I'm not saying POPIA has solved this, I'm saying the problem we've always had, and I'm not sure we've solved it as yet, is that when we have a data breach, whether it's for confidential information under NDA or a POPI breach, right? In the normal course of the flow of data, we have huge trouble proving where the leak happened. And that is why it is critical, as much as it has always been good, responsible business practice to safeguard information, for us to understand how the flow works so that we are able to say, this is where it leaked. It's almost like a leaking pipe, right? Unless there's a bunch of water spurting out of it, we can't say where the leak really is unless you get someone to go and check, and some professional that can tell you, hey, it's over here, it's hairline thin, that's why you can't see it. So the point is that either we need to understand our proverbial pipe, our system well enough in order to detect it ourselves, or we need to get suitably qualified professionals to say, I've analyzed the system, the back end, the metadata, whatever tools you have at your disposal, this is where the leak happened, I can prove it, and this is where we can then quantify our damages and we can report to the information regulator. So it imposes more responsibility and a deeper practical, technical understanding.
Responsibility and a practical understanding. We have about 10 minutes left, and I want to ask a few more questions. When we bid, the information that we provide in our responses are by nature highly confidential. It is not only people's information, it is our company's information, it is our company's IP, pricing. I mean, this is what makes my company different from your company, from the next one. This is seriously sensitive information. Has there been any cases yet so far with fines or imprisonment where tenders, proposals, business development documents have been leaked the leak in the pipe has been found and there's case law to this specific point.
I really wish I could have said yes, but no, we haven't seen it. But any of us who are working from a procurement point of view, whether we are role players in submitting bids, whether you're an attorney like myself, often finding ourselves in court against organs of state for procurement processes gone wrong, we can tell you definitively off the record that we know of various organizations that have been completely prejudiced because of a leak of that information. You'll find also, and I think some of the bidding officers in the room may agree with me, often when we get rejected, it's good sales training for all of us to ask why. And often without two thoughts about it, we get gross detail about who was successful and what their price was and what favorable terms they proposed in comparison to us. And I can tell you as a fact, we do the same thing, and often we have been supplied with that information, but no one has actually taken it up. And I encourage all of us, we need to be much more vigilant about our data and about our personal information, because if we are starting to debate WhatsApp's new privacy policy, which we spent the greater part of 2021 doing on all sorts of platforms, it's a start for us to ask these questions. But if I send this, where's it going to end up? Who's going to access it? Is it going to lie on someone's floor, literally, in a government office? Is it going to end up in a bin, not being shredded? Where is this? We need to start asking these questions. But I think we are all in a tough economic situation. We are very reluctant to ask those questions. So maybe not as grossly as I've portrayed them. Maybe we need to find more diplomatic ways of asking those questions. We are entitled to those answers. Where will it be stored? Who will have access to it? And what is your department's policy on returning the information to us?
Scary, scary, scary thinking of what information does get thrown around willy-nilly. Before we wrap up, are there any more questions? You're welcome to type them while I ask my last question. Nicolene, 2 or 3 practical tips for bid managers, for procurement people, for salespeople, when we deal with the work we do.
First and foremost, I know some of us fall into this position, and we qualify ourselves with different things, but I would encourage one practical thing. If you are in the mood for expanding your horizons, project management training is very useful to us, because it teaches us to not only get a sense of how to better navigate the procurement landscape and how that system or process works, but it also allows us to create our own internal process, particularly if we belong to an organization where there's no such system or process in place, so that you can obtain the necessary consents in a smooth, well-oiled fashion. If you insert a bid, you're successful, potentially to look at ways where we use the collection of testimonials or feedback, customer care, as a way in which we can also seek the consent, and then we do it without having pressure. So collaboration is the second tip. Looking at project management, some collaboration between departments, particularly in bigger organizations, and seeing how we can help each other in getting the consents in place and understanding the complexities of what is expected from all of us. And then lastly, I think we need to have practical conversations in our workplaces, in our organizations. For example, and I can say in our organization, we are 80% under 30. So you would expect that we have a very young generation, very technologically savvy, but I have not found that necessarily always to be the stereotypical case. We often find them without thinking, using a device that connects to an open source network, which invites all sorts of things into the device. And once it's on one device, because we are working with such interlinked technologies, it often spreads.
Yeah.
So as the organization, make sure that you've got perimeter security, but not only perimeter security. At law firms, we are expected to have at least 3 layers of perimeter security over and above whatever else we do. So some training, it's been proven internationally that 90% of data breaches are actually not malicious in intent. It's someone who accidentally sends the wrong email to the wrong person, clicks on a suspicious link because they were not educated to know it's a suspicious link in the first place. So let's not assume that the people who are supporting us in our organizations know what we know. Let's rather be practical and have these conversations, have the training sessions, and educate and learn together as to how we can just change a few behaviors and be a little smarter than the scamsters out there, and protect ourselves in addition to our perimeter fencing.
Okay. Thank you. That's very insightful to know our younger generation is not that street smart when it comes to security. One last question that has just come in, and then we can wrap up and be secure. Alfreda's asking, what remedy do I have as a bid manager when I find out that a resource we are using in our bid did not give permission or is not aware that our company is using his or her CV? Particularly happens when using individual consultants that are not full-time employed by your company. So I'm managing a bid, and I find out that the person I've been told to use in the bid has not given consent for their CV, their role to be used. What is my remedy, or what is my responsibility?
I would recommend that you immediately bring this to the information officer's attention. Larger organizations often have more than one information officer, meaning one main officer and a number of deputies. It seems that most have a information officer and a deputy, but it could be more than that. Find out who that person is. Bring it to HR's attention in addition to that if you have a loose-standing HR department. And make sure that even if you don't get a response, that you have a record that you've brought it to, at the very least, the information officer's attention, and that you've recommended that they instruct you as to whether or not you should try to get your consent, or whether we should withdraw this person's participation.
So we would then typically add it to our risk register, because
Yes.
on every bid we keep a risk register.
Absolutely, absolutely document it and make sure that through the governance structures of your project that you communicate that accordingly. And
so who
that
would
you have
get
a
in
record
trouble?
of it.
Just by the way, who would get in trouble if
The information officer, who
not the bid manager,
in turn may then proceed against you as the bid manager on a disciplinary basis, saying that you breached your employment terms or you were negligent. So cover your bum, as they say.
Thank you. Nicolene, thank you very much. Thank you to everyone who participated and asked questions. You call it practical conversations. I like it because I want to know exactly what is right, what is wrong in my day-to-day work with sensitive information. So thank you very much. And I think we should probably have one of these practical conversations again in the new year. So thank you, Nicolene. Thank you, Ilse, and thank you to everyone who joined and who asked questions.
Thank you so much, everyone, and thanks for having me.
Thank you, Nicolene. Thank you, Izane. Maybe just we are out of time. Nicolene, if anyone needs some questions or have some specific information they require from a legal perspective, how can they get hold of you?
On our website at www.schoomanlaw.co.za, there's a very friendly pop-up. Her name is Lexi. She's our chatbot assistant, and she would be able to help you arrange a 10-minute free chat with me if you have that one question, or maybe we didn't get to your response today, or if you just didn't feel comfortable to ask it in the open forum. More than happy to take your call and for us to get to know each other a little bit.
Thank you so much. And then, of course, lastly, but not the least, if any one of you in our audience today needs some burden proposal support, you're welcome to contact us on www.nfold.com, and we will certainly be able to engage with you and have a chat and see how we can assist you and inspire your success. Thank you so much, ladies. Goodbye,
Thanks, everyone.
Thanks,
Have
everyone.
a spectacular day.
Bye.
Thank you.
Bye-bye.